I'm Vice President Asbury from the Fair Work Commission. I'm pleased to introduce Deputy President Saunders, who is our National Practice Lead for Unfair Deactivation, Unfair Termination and Unfair Contracts.
Thank you, Vice President. Today, I'm going to discuss parts of the Fair Work Commission's new jurisdiction under the Closing the Loopholes Act No. 2, the new unfair contracts jurisdiction for independent contractors. Now, provisions similar to the Independent Contractors Act have been included in the Fair Work Act so that the Fair Work Commission has jurisdiction to deal with unfair contract claims by some, but not all, independent contractors. These new provisions of the Fair Work Act commence operation on 26 August 2024 or earlier by proclamation. You'll see from this slide that if an independent contractor earns at least as much as the contractor high income threshold, then the independent contractor will have to take their unfair contract claim to a court under the Independent Contractors Act. The contractor high income threshold has not yet been determined. It will be set by and included in the regulations. If an independent contractor earns less than the contractor high income threshold, they'll be able to come to the Fair Work Commission to have their unfair contract claim heard and determined. The process for unfair contract claims in the Fair Work Commission will involve first the filing of an application by an applicant. Secondly, responses will be filed by other parties to the services contract. Under the Fair Work Act, members of the Fair Work Commission are given a broad discretion in deciding how they will deal with these types of applications. And if the matter ends up in a final hearing, the ultimate question will be whether the services contract contains any unfair terms. If so, orders may be made, and I'll say something about the nature of those orders a little later today. Now, in terms of applications, the application must relate to a services contract, and I'll explain in a moment how a services contract is defined. The applicant to the proceedings must be a party to the services contract or an organisation, such as a union, that represents the industrial interests of the party to the services contract. The applicant must be a person, which can include a corporation. We know it's not unusual for independent contractors to set up small companies to provide their services. In those cases, assuming the contract is made between the small company and the client, the small company would be the applicant to the proceedings. So, for example, if Jim Smith used his company, Jim Smith Pty Ltd, to enter into a contract to provide services to another company, then Jim Smith Pty Ltd would be the applicant in the claim relating to the fairness of the terms of the services contract. Now, services contracts are defined in Section 15, capital H of the Fair Work Act. They have a number of elements. The first element is that we're talking about a contract for services. And that's opposed to a contract of service. This makes it plain that we're dealing with independent contractor agreements, not employment agreements. These laws do not apply to employees. Next, the contract must relate to the performance of work under the contract by an individual. So even if the party to the service contract is a corporate entity, such as Jim Smith Pty Ltd, the work being performed under the contract must be done by an individual. So in my example, that would be Jim Smith. There also has to be a constitutional connection to the services contract, and this will most easily and readily be satisfied where at least one party to the contract is a constitutional corporation. And the services contract may also include a condition or a collateral arrangement that does not form part of the services contract, but relates to the services contract. And there is a significant body of case law under what was Section 106 of the Industrial Relations Act of New South Wales about what is a condition or a collateral arrangement. No doubt that jurisprudence will be looked at carefully in working out how these provisions are to be interpreted in the Fair Work Act. It's important to understand that an unfair contracts application can only be made in the Fair Work Commission if the services contract was entered into on or after commencement. which is 26 August, or earlier by proclamation. So if the services contract was entered into before 26 August 2024, it continued after 26 August 2024, the worker under the contract could not bring an unfair contracts claim in the Fair Work Commission because the contract was entered into before 26 August. There's no qualifying period of service that needs to be satisfied before a person could bring an unfair contracts claim in the Fair Work Commission. So an independent contractor may enter into a contract, a services contract, on the 26th of August 2024 and make an unfair contracts claim in the Fair Work Commission on the following day. There's no time limit under the legislation for an unfair contracts claim to be made, so it may be made many years after the contract was made and after the unfairness in the terms became apparent. However, in an important decision involving Mr. Gerard and Mayne Nicholas, a full court of the Industrial Relations Court of Australia considered this issue in the context of the Independent Contractors Act. And in that case, the full court observed that the giving of relief under the unfair contract provisions is discretionary, and the court was entitled to take into account any delay in the making of the application and any prejudice occasioned to the other party in exercising that discretion. So we'll have to wait to see whether the same approach will be taken in the Fair Work Commission. In addition, under the Independent Contractors Act, which I've said is in similar but not the same terms as the unfair contracts provisions of the Fair Work Act, an unfair contracts claim may be made even if the services contract has been terminated and may involve the retrospective variation of the services contract. Again, we'll have to wait to see whether the same approach will be taken in the Fair Work Commission, and I'll examine this issue a bit further when I discuss remedies. Now, in terms of a response, the Fair Work Commission is working to establish forms and rules which will facilitate each party to the services contract being able to respond to the application to set aside or vary the services contract. Now, the Fair Work Act requires that our procedures for dealing with unfair contract claims must be quick, flexible and informal. Initially, at least, unfair contract claims will be allocated by regional coordinators within the Fair Work Commission to members such as myself without first going to staff employed by the Fair Work Commission as conciliators. This may change in the future depending on the volume of cases we receive and the development of the jurisprudence to give guidance on the meaning of these provisions. The Fair Work Act gives flexibility as to how unfair contract claims ought to be dealt with by the Fair Work Commission. It's likely that matters will first be conciliated, and if conciliation is unsuccessful, then the matter will be listed for a final hearing. Conciliation is a process, like mediation, where the Fair Work Commission works with the parties to see whether they can agree on an outcome to resolve the dispute. Conciliation might involve a member of the Fair Work Commission expressing an opinion or making a recommendation, but those things will not be binding. It'll be up to the parties to reach agreement or not. Any conciliation conference conducted in relation to an unfair contract claim must be held in private. That's provided for under the Act. The conciliation might be conducted in person at the Fair Work Commission's premises, by telephone or by video conference using our Microsoft Teams platform. Members of the Fair Work Commission also have the power to dismiss an application if a party fails to attend a conciliation conference or a hearing. It's important to appreciate that the focus in unfair contract claims is on the fairness of the terms of the services contract, not whether some conduct under the contract is unfair. Now, this is clear from section 536 NA1 of the Act, which empowers the Fair Work Commission to make an order if we are satisfied that the services contract contains one or more unfair contract terms. So what this means is that an applicant must be able to appoint to a term, one or more terms in the services contract, which they say is unfair. For example, the services contract may permit one party to terminate the contract on 1 minute's notice. An applicant has been providing services under the contract for months or perhaps years, may allege that the term permitting termination of the contract on 1 minute's notice is unfair and instead the contract should be varied to require a minimum notice period of, say, 1 week or 1 month or some other amount. In contrast, if an applicant complains about the conduct of the other party, which they say was unfair, and that conduct is not governed by a term of the contract, then the applicant would not be able to bring an unfair contract claim. For example, if an applicant complained about the way they were being treated or spoken to by the person giving them a task to do, that would not be a claim that the services contract contained an unfair term. It would be a claim about conduct and could not be pursued as an unfair contracts claim. Now, in terms of working out whether a term of a services contract is unfair, Section 536 NB of the Fair Work Act sets out the matters which the Fair Work Commission may take into account. These include the relative bargaining power of the parties. So, for example, one party may say to the worker that if you want the work, you must sign these standard terms, and the worker may be in a situation where they have no option but to sign the contract. In this type of case, there may be an inequality of bargaining power, which might, but not always, will result in the production of a services contract that contains unfair terms. Another factor we may take into account is whether the term of the contract imposes a harsh, unjust, or unreasonable requirement on a party. For example, the contract might require the worker to work, say, a 10-hour shift, say until midnight, and then recommence at 4 a.m. the next day. That might well be considered to be a harsh or unreasonable requirement. We can also have regard to whether the services contract provides for total remuneration, which is less than an employee would receive for performing the same work. For example, you might have a person engaged as an independent contractor to provide cleaning services, and it might, under that contract, provide for them to be paid less than they would have been paid had they been performing the work under the Cleaning Services Award as an employee. We can also have regard to whether the contract term is reasonably necessary to protect the legitimate interests of a party to the contract. By way of example, the services contract might prevent the worker from being able to work for any other company in the same industry for a period of, say, 3 years after termination of the contract. In most circumstances, a post-contract restraint provision, which extended for a period of 3 years after termination of the contract, would not be reasonably necessary to protect the legitimate interests of a party receiving services. Another factor is whether the services contract displays a significant imbalance between the rights and obligations of the parties. So, for example, a services contract might require a worker to be available to perform work, or provide services rather, 7 days a week, 24 hours a day. But the contract might also give the entity that engaged the worker the right to cancel work or a task or a shift on, say, 1 minute's notice. A contract of that kind would be likely to display a significant imbalance between the rights and obligations of the parties. So these are some of the matters that may be taken into account in determining whether a particular term of a services contract is unfair. Not all terms in a services contract may be set aside or varied. Only unfair contract terms which in an employment relationship would relate to workplace relations matters may be set aside or varied. And workplace relations matters are defined in section 536JQ of the Act. That section actually defines what is and what is not a workplace relations matter. And by way of example, workplace relations matters include remuneration, hours of work, terminating contracts, etc., and specifically exclude from the definition matters such as superannuation and occupational health and safety. Now, on the question of relief, the Fair Work Commission has the power to set aside or vary all or part of a services contract, provided the part we vary or set aside would, in the employment relationship, relate to a workplace relations matter. But importantly, we do not have any express power to award compensation. This is to be contrasted with other jurisdictions, sections such as section 106 of the Industrial Relations Act of New South Wales, where the Commission had the power to make such orders as to the payment of money in connection with any contract varied as it considered just in the circumstances.